Intellectual property can be a major issue for international companies setting up in China.
I think the first thing is just not to be afraid to come here. Most of the successful IP stories have come from New Zealand companies who have recognised that their IP are their crown jewels, and they really have to take steps to make sure that they're not stolen.
Intellectual property is something that everybody fear. How come? Is in one way we are also very fear of our product being produced by somebody else and by copied by somebody else. What we're going to do as intellectual property is you have to trademark your brand in China, and this is one of the things I did. Secondly, I think the fear of somebody copying a product is there, but I do not think it's very critical today. Why? If you are good at it, and if you know the ways of doing things, nobody can copy exactly the same. And it will not produce as good as you if they copy here.
When it comes to IP, our company has a lot of fear in it too, down home. But I don't have the same fear. People at home talk about employees leaving you and taking with them formulations, because formulations is our IP, taking other knowledge. I don't think that would happen to us. But we looked at bringing a product here and manufacturing here some time ago, and there was some real fears about the rubber formulations, because that was the heart and soul of that business. But to be fair to the Chinese too, they've taken many cases, and last year's 3,500 cases on intellectual stealing, and they're putting more money into it, and they are addressing it. They will eventually address it, but it'll take many, many years.
There's a good many people have said to me, but China, what about your IP and getting it ripped off in China? And I say, well, quite frankly, we've had more IP ripped off in Australia than anywhere else.
One of the things that we've introduced in China is, and it stands us apart from a number of other domestic manufacturers, is that you can give NDA your drawings, your technology. We will fabricate it and deliver it, but your IP is protected, and that's why we haven't gone into contract manufacturing, which puts our customers' technology at risk, we believe.
Really, yeah, we have some concerns about the IP things when we're doing business in China. Currently, we're mainly doing assembly job. We have some manufacturing capacity and fabrication capacity, but we cannot make all the things, which means we have to have some of the stuff outsourced. In order to get around with the IP things, we separate the machine into different parts, which means, you know, we have not only one suppliers, we have maybe several, and we give different drawings to different suppliers, and they only make one part of the machine, not all the complete machines. And then when they ship all the machines to our factory, we assemble them together. That's one thing. But eventually, we will have more things made in-house that will, you know, protect all the IP problems.
To protect your IP, the first thing New Zealand companies should do is register their rights. And by that, I mean trademark rights, patent rights. Although there's no compulsory registration of copyright, we do recommend recordal of copyright. And various other non-IP rights also require some form of registration process. The second thing I would say when New Zealand companies look at their legal plan is to ensure that they have people on the ground that understand what the legal responsibilities and obligations are, and that those have been properly translated and understood. And I would say the third sort of fundamental issue for New Zealand companies is to ensure that they actually enforce or actually honour the rights that they have under their contracts and the obligations as well that they have. Administrative action in the context of intellectual property is a very fast, cost-effective means of seeking redress for an infringement or a breach of some legal obligation. And most forms of intellectual property have a relevant administrative body that governs that situation. And I would say 90% of the cases in China where infringement take place are dealt with through the administrative process. It's fairly cost effective, takes about 3 or 4 days to make a submission, file that submission, and then have that submission dealt with by the authorities. New Zealand companies looking at the cost issue, I think, need to be aware, first of all, that if they don't properly manage it and budget for it, it can become uncontrollable and can lead to huge sort of out-of-control costs. Cease and desist letters are a very effective way of dealing with infringement if infringement arises. In terms of costs, generally as they would be in New Zealand, so anywhere between sort of $700 to sort of $1,500. Administrative action, that whole process, right through to punishment, the costs are going to be somewhere in the region of $4,000 to $8,000. We're seeing some very good, fair, fast decisions coming out of the Shanghai courts and the Beijing courts, and more now coming out of the Tier 2 cities.
China is taking huge steps to prevent infringement across the board.
From an intellectual property point of view, what China is doing from a business angle is, I think, more advanced than any other country that I've been to be honest. And that is because intellectual property is not a legal discipline anymore, it's a business tool. In most companies in China, IP is not handled by a lawyer, it's handled by a business person who understands how IP and business go hand in hand. And that means that Chinese businesses are becoming very savvy about how to use technology, how to use their research, how to use their brands, their patents in a very smart business way. And I think that will benefit the whole IP industry, and the companies that will succeed long term will be those companies that have put these systems in place and been sensible in terms of making sure that the basics are right.